The First Amendment protects freedom of expression, including freedom of speech, of the press, of assembly, and of association. Protected speech. Where protected speech is at issue, the level of scrutiny depends on whether the speech restriction is content-based. Content-based restrictions, strict scrutiny. This occurs where government seeks to restrict speech because of its content. This is based on the subject matter or viewpoint. Content neutral restriction is intermediate scrutiny, and this occurs when the government's restriction applies to all expression regardless of the content or viewpoint. Unprotected or lesser protected speech. Some categories of speech receive lesser or no First Amendment protection. This speech restrictions under the appropriate test given the type of speech. So speech on government property, public forum doctrine, special rules apply depending on whether the government property is a public forum, designed public forum, or non-public forum. Freedom of the press. Press has a right to publish matters of public concern. Any restriction or punishment must be narrowly tailored to further a state's interest of the highest order, essentially strict scrutiny. Public forums are government property that the government is constitutionally required to make available for speech, such as the sidewalk or the park. Regulations must be content neutral. So the test for public forum restrictions is to be upheld. The restriction must, 1, be content neutral, only regulate time, place, or manner of speech. The restriction is content-based, strict scrutiny applies. 2, be narrowly tailored to serve an important government purpose. 3, leave open adequate alternative channels of communication and does not have to be the least restrictive alternative. So permit fees that vary depending on the type of speech are content-based and unconstitutional. Note, when held open for speech, restrictions on speech in limited public forums are analyzed as public forum restrictions. Government properties that are not public forums may impose greater restrictions on speech. There are 2 types. Limited designated public forums and non-public forums. Limited designated public forums. Government properties that the government opens for speech but can close at any time. So for example, public school facilities for Girl Scout meetings, advertisements in public spaces. The test is the same rule applies as for public forums, but only apply when the government property is open for speech. So for example, it must be content neutral and strict scrutiny applies. So when closed for speech or restricted to certain types of speech, we must analyze a non-public forum. Non-public forum or government property that can be closed to speech, like a military bases or airport. The test is that the government can regulate speech if the regulation is 1, reasonably related to some legitimate purpose, and 2, viewpoint neutral. Content neutrality not required. So government can allow speech on some subjects, but not others. Yet, if it opens speech to a subject, it cannot limit the speech to only one view. Prior restraints. involve a court order or other ban on speech or publication before it occurs. So strict scrutiny applies if the prior restraints are difficult to uphold. Often arises as court order or injunction preventing speech. Requirements are that to be valid, a prior restraint requires government interest. There must be at least some significant government interest justifying the restraint, such as special societal harm. National security may be sufficient, and national security may be sufficient harm or government interest, but the harm must be more than theoretical. Procedural safeguards for those whose speech is restrained. Safeguards must ensure restraint is narrow, reasonable, and definite, and provide for prompt final judicial determination. Preliminary injunction to prevent pre-trial discussions in order to preserve a fair trial, only valid if it's the only way of preserving a fair trial. Note, plaintiff must comply with an injunction until it is vacated or overturned. Plaintiff cannot challenge a violated injunction. Permits and licensing. Government may require licenses or permits for speech only if it has reasonable justification for doing so. Requirements for permit or license must be similar to a rubber stamp process and must provide review for denied permits and licenses. Plaintiff can challenge a denial on constitutional grounds even if violated. Laws can be struck down due to grounds of vagueness or overbreadth. So vagueness exists when a law is vague if a reasonable person cannot tell whether this speech is prohibited or permitted. Laws prohibiting people from assuming or assembling or conducting themselves in a manner annoying to a passerby is unconstitutionally vague because a reasonable person must guess as to what the behavior is punishable. Overbreadth. A law is overbroad if it regulates substantially more speech than the Constitution allows to be regulated. An overbroad law restricts unprotected speech, but in doing so, also restricts protected speech. Law prohibiting all live entertainment may validly restrict obscenity, but also invalidly prohibit protected speech in concert or theater. If a speech restriction is overbroad, it cannot be enforced against anyone, even one whose speech is not protected. Note, fighting word statutes are almost always unconstitutionally vague and overbroad and will not be upheld. Symbolic speech refers to expressive or communicative conduct intended to convey a message. The test is government can regulate symbolic speech if 1, the regulation furthers an important government interest, 2, that government interest is unrelated to suppression of the message, and if the restriction is aimed at speech more than conduct, it is likely unconstitutional. 3, the impact on speech is no greater than necessary to further the important government interest. Examples include burning the U.S. flag, which is protected symbolic speech, burning a cross, which is protected unless intended to threaten, and public nudity is not protected.